So, Renato, is Ghislaine Maxwell going to get let off the hook?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rengappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal and national security analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Well, Asha, the Epstein story won't go away. Obviously, this past week we had Ghislaine Maxwell and her attorney meet with Todd Blanche, the Deputy Attorney General, for a secret interview, essentially, in which she was providing information pursuant to a proffer agreement. And at the same time, there's been, I would say, newfound attention on her Supreme Court cert petition, in which she's trying to get the United States Supreme Court to overturn her conviction.
Right. I think it's helpful to kind of look at the different escape routes that Ghislaine Maxwell may possibly have. So one is an outright pardon from Trump. She was convicted of federal crimes, and that is something that could happen. He hasn't said that he would, but he hasn't said that he wouldn't either. And he's pointed out that he's allowed to do it. So that's sort of the direct route. Then you've mentioned before in previous podcasts that with this meeting, and of course, we don't know what actually took place, but that there is a possibility of a Rule 35 reduction in sentence because of cooperation of some kind. And so that is something that the Department of Justice could do on her behalf. Is that right?
That's right. That's correct. In fact, I would think that the Trump administration would like that better, because once you give a pardon, like, you can't take it back really. And like, then she's off the hook and she has less incentive to continue to play ball with you. Whereas just like in the Eric Adams case, if, you know, in a prior podcast, we talked about how the Trump administration wanted to dismiss his indictment without prejudice so they could always bring it back if he didn't, fulfill his end of the deal. And here, I think they might like having a situation where she's quote unquote cooperating. And as long as she keeps giving them names of Democrats or whatever they want, then they can, potentially increase their cooperation credit as a result.
So let me just ask a question on the Rule 35 motion. Does the court typically give prosecutors a lot of deference in terms of how valuable the information is? Because reading Rule 35, it seems as though, if the new information is given within a year of sentencing or something, then, that's one thing. But there is language that says if this is being given more than a year after sentencing, then for a reduction in sentence, it has to be like information that the defendant didn't know at the time, or information that prosecutors didn't know would be valuable at the time. And there's all of these conditions. And so I'm just wondering, how realistic is it that even if DOJ were to argue for this, that a sentence reduction would even be granted in this case?
Yeah, it's an excellent question. I mean, as a practical matter, it's fair to say that there was all sorts of reason for her to have known of this information, right? It's not like anything new is going to be happening with Jeffrey Epstein in the immediate past that we've had over the last X number of months. It's not like prosecutors wouldn't have been interested in this stuff earlier. Generally speaking, Asha, judges are extraordinarily deferential to the government because the government is better able to judge these issues than the judiciary, and judges don't want to second guess the government's view of whether information is valuable or not. That's usually the approach that judges take. Now, obviously, this is not your typical case. In other words, if this was United States versus Asha Rengappa, and 2 or 3 years after your conviction, prosecutors came before some random judge and said, look, Rengappa came forward with some important information and blah, blah, blah. A judge might be like, okay, all right, fine. I'm not going to spend a lot of time scrutinizing it. Obviously, this case is different because the world is going to be looking at this. This involves, Justice Department that is obviously its activities are in question. This involves activity for which the president has been making. We can talk about that in a minute. President Trump has been making some very interesting statements about Jeffrey Epstein as of late. And there's a lot of question about whether his name is in the lists and the files and so forth. And so there's all sorts of reasons to question this, right? And so I think a judge very well may scrutinize it in this particular instance.
Also, I think it's worth pointing out that she has a 20-year sentence, which is a pretty decent chunk of time. I mean, frankly, I personally think she should be put away for longer, but a reduction in sentence of a 20-year sentence, I would think could still be significant for her. I mean, I don't think the judge is going to be like, okay, get out of jail, see you later. So it might not be enough of an enticement for her. Or, maybe
maybe it is.
Maybe it
when
is.
You're in prison for 20 years, 10 sounds a lot better, right? I mean, at her age.
Yeah. And we should talk about that more if that's where it goes, because I'm really interested to know where the victims come in that, because I mean there was a very extensive pre-sentencing report that had extensive victim statements about her culpability, and that I think often gets overlooked in a lot of the commentary about her.
That's right, and in particular, very substantial allegations that she participated in abuse.
Yes.
Not just that she enabled or promoted or worked with Epstein and Epstein's sexual abuse of minors, but actually she participated in the sexual abuse of minors herself.
With him, yes.
Right.
And so, I think that is such an important point that, yes, she was the person who was bringing in, these girls and recruiting them, et cetera. But I think to suggest that she's sort of this outside player really minimizes her culpability of her actual participation. Like, she was very directly victimizing these girls herself for her own sexual gratification. And I think that it's just, I feel like that's getting glossed over in a lot of the discussion about her. So, okay. So those are two avenues. There's the pardon, the Rule 35. And then there is potentially the Supreme Court get out of jail free card. And that would really be a get out of jail free if the Supreme Court agrees with her, because we talked previously about the sweetheart deal, non-prosecution agreement that Alex Acosta, then U.S. Attorney of the Southern District of Florida, reached with Epstein in 2007. Alex Acosta, who later became Trump's labor secretary. Just letting everybody know. So that non-prosecution agreement, in which Epstein agreed to plead guilty to a state charge and serve jail time and register as a sex offender in return for the feds dropping all the charges against him, which is all, sketchy as all get out to begin with, also included language that agreed not to prosecute any co-conspirators of Epstein, including those that were not known to the U.S. Attorney's Office at that time. They had 4 co-conspirators, accomplices that were in their crosshairs, but it very explicitly says that it's not that they're agreeing to not only not prosecute those 4 people, but basically anyone else.
Yeah, and it's an extraordinary provision. It's not ordinary at all. Typically speaking, one thing I would just say is that when the government is agreeing not to prosecute somebody or to give immunity or anything like that, typically those agreements are written very narrowly. They're written to only cover conduct that is known by the government. Usually there's very strict limits put on it. So in other words, here is what we know about you. We are giving you immunity on just the 4 corners of the things we know. And if you do something else, or if there's something you didn't tell us, or there's something we don't know, or there's someone we don't know that's not covered by this very narrow agreement. So that's, I would say that portion of the agreement is, incredibly unusual. And of course, there's another provision, which I'm sure you're going to get to, that's also somewhat unusual about this.
Yes, there is something else unusual about the language of that, which is in the part of the agreement that says that the prosecutors will not prosecute Epstein for federal crimes. It specifies that the district will not bring charges against him. However, in the clause that references the co-conspirators, the agreement says the United States will not bring charges against any co-conspirators. And so what Ghislaine Maxwell's argument is that she says, I'm a co-conspirator, or I'm alleged to be a co-conspirator, and therefore I'm covered by this agreement. And the very fact that this agreement distinguishes between the district bringing charges and the United States bringing charges means that the latter provision that applied to the co-conspirators is actually meaning to include the entire Department of Justice, that all of the U.S. Attorney's offices, not only limited to the Southern District of Florida, and therefore the Southern District of New York was bound by this non-prosecution agreement.
Yeah, and it's very important because this is not your typical appeal, not your typical Supreme Court argument that you have in a criminal prosecution where, hey, I have a get out of jail free card and so on. What I will just say too, what's something that's atypical here, Asha, is the Justice Department's policy has been and remains that districts can only bind themselves and not other districts when they're offering immunity or non-prosecution deals, et cetera. So typically, if someone wants to get, for example, immunity that is global and not from that particular district itself, they actually have to go to the court and get the court to immunize them. Okay, this is not an immunity deal, but I'm just offering that as an analogy. It was actually very important historically in the Monica Lewinsky case, where she would not accept immunity from Kenneth Starr because she was afraid that some other Justice Department entity might prosecute her, and she demanded transactional immunity via the court. Here, U.S. Attorney's Office in the Southern District of Florida is purporting to bind all these U.S. Attorney's offices elsewhere, contrary to DOJ policy. But she has argument there, not just based on the language of the agreement, but one thing that's very important in the cert petition. So in a cert petition is where you actually ask the Supreme Court to review the case, because the Supreme Court doesn't review the vast majority of the cases that it's asked to review from the Court of Appeals. But one thing that's important, Asha, is that a majority of the circuits, and we can get into the details on that, but a majority of the courts of appeal throughout the country actually hold that a non-prosecution agreement with one U.S. Attorney's Office binds them all, absent like express language to the contrary. And that is a problem for the Southern District of New York. And it also means that the United States Supreme Court is more likely to take that case, because typically the Supreme Court likes to take cases primarily when there's a disagreement amongst the courts of appeals.
Right. When there is a circuit split, as it is called. So I will first give an argument that I think is in Ghislaine Maxwell's favor here, particularly with this court. Mm-hmm. And they don't make this argument in the cert petition, but this is something that I could see at least some of the justices, if they were to take this case, being, having an affinity for, which is, if you subscribe to the theory of a unitary executive, the idea of different U.S. attorneys' offices saying different things doesn't make any sense, right? These are all U.S. attorneys' offices under the unitary executive theory are basically little mini mouthpieces for the president of the United States, because there's only one executive power. And so I could see this idea that you can have contradictory, approaches, that when one U.S. Attorney's Office speaks on behalf of the United States, that then it is the United States. I mean, it's basically the executive branch speaking. I mean, that's sort of what I could see happening, but I think that there's also a couple of arguments very practically about this particular non-prosecution agreement that cuts against her. And
yeah, I think it's interesting. First of all, I think this is really an interesting legal question. Yeah. Obviously, it's very important. And I think, as we both described, Ghislaine Maxwell is a monster who did just horrific things to children. And so obviously, there's a strong public interest in ensuring that she's appropriately punished for that heinous crime. But when you look at the sort of the legal issue here, typically speaking, first of all, when you're drafting, when you're looking at contracts, they're usually construed against the party that's drafting it. In this case, it's usually the government. The government, there's usually a power imbalance between the government and the defense. And so I think, the government can be held to a standard there where unless they're really specific about what they're trying to do, there's an assumption that the defendant is, entering into a deal because they have whatever understanding they have based on whatever the government drafted up. So I could see a lot of policy reasons why you'd want to force the government to be really explicit if they want to limit what they're doing in their deals. Okay.
Well, and that happened with the Hunter Biden plea deal. If you'll remember, right, that fell apart in court because it was not clear on what exactly the government was agreeing to take off the table for future prosecution and what they were not. And they weren't able to answer. And my interpretation was that the judge in that case said, I'm not going to approve this deal because she was looking out for the defendant's interests. I mean, basically she was saying there's no meeting of the minds here, because if he's on a different page, if this defendant believes that what he's agreeing to is that, the U.S. Attorney's Office or the special counsel is not going to ever prosecute him for, I forget what was still on the table, dealing with Burisma or whatever, that they basically didn't have a meeting of the minds.
Yeah. I mean, a lot of times what would happen in practice in a situation like this, the defense would take the deal and then they would years later, the government, then they would just, in their argument, I would understand, would be like, hey, the government gave us a broad sounding vague deal. This should preclude this prosecution. And I mean, that's really
kind of what's happening here.
That's exactly what's happening here, Asha.
Except I want to throw out a couple of things to consider. So as you know, I went into the weeds on the OPR review of this highly unusual non-prosecution agreement that no prosecutor that I've talked to has ever seen anything like it. And when, they're obviously interviewing the line prosecutor and other people involved, many years after the fact. But the AUSA who was working on this case, and by the way, had a 60 count indictment ready to go. So this attorney really wanted to go after Epstein. It was, the decision not to was made above her pay grade. What she says is that, the 4 accomplices that we had in our crosshairs at the time were not people that we would have charged. Because, if what Epstein was doing was essentially kind of a sex trafficking Ponzi scheme where he would bring, Ghislaine Maxwell would bring in these girls, he would abuse them, but Ghislaine Maxwell wasn't the only one that was recruiting more girls into this enterprise. Sometimes the girls who were victimized were themselves sent out to bring in their friends or, other people they knew from school and things like that. And I think this prosecutor was saying, basically we considered those girls victims, even though they were quote unquote helping, that, if we were to uncover, not only were we not going to charge these 4 people, but if we were to uncover more an extensive network of girls who were themselves abused, and then they were sent out to get more, victims. Those are just not the kind of people that we would charge. So that was who we imagined would be encompassed in this group, because Ghislaine Maxwell wasn't one of those 4 people. So I would argue, point number 1, she is not the kind of potential co-conspirator that the government was agreeing not to prosecute.
I think the problem there. So here, first of all, I just want to say to our listeners, viewers, have proper context. It's very common, just as somebody, I myself worked child abuse and child exploitation cases. It's very common for victims to themselves commit offenses. First of all, often there's prostitution involved, which is obviously can be a criminal offense depending on the state, but also they will sometimes enable the person who is victimizing them, and they might actually have affection for that person. There might be a relationship that they're being manipulated and deceived by somebody who is masterminding this criminal scheme. So that don't be too judgmental about victims who are doing that. Like, you have to understand, it's a complicated, I would say, dynamic there. So I just want to say that because I think it's important context. But I guess what I would say is the problem for the government there is the words of the deal really matter. And none of it's really spelled out. Like, none of that is spelled out in this clause, and it's pretty sweeping and broad. And that's why I think the government is relying so heavily on the prosecution, is relying so heavily on the fact that one district couldn't bind another, because the language seems broad on its face.
Yeah, I mean, but that's really tough because that's an internal policy, right? That's not a legal, I don't know that is a legal argument. I mean, that's a shakier argument. And I would say a better legal argument is kind of to go back to that Hunter Biden example. There's no meeting of the minds. I mean, that agreement was reached with Epstein, and, Ghislaine, if she wasn't a part, I think that even if the language was broad to encompass people not known to the U.S. Attorney's Office, then you can't, just as a matter of contract law. And she's even kind of acknowledging that. She says, I'm a third person beneficiary. She's not even saying I'm a party to the agreement.
Yeah, I hear you on that.
Not a party to the agreement.
I hear you. Although, yes, the United States, though, is making a binding promise pursuant to an agreement, arguably. Now, what the government prosecution is saying is a few things, right? One thing you should note, I mean, the real issue here, Asha, is does one U.S. Attorney's Office have the power to bind another? Okay. In other words, I can enter an agreement with an affiliate of a company, but it may not have the power to bind another affiliate, right? Like, you have a distribution arm of a company signs an agreement with you, but they don't have the power to bind the home office back in some other country or something along those lines. And here, I think one of the things that the government is using, the prosecution is using, is this agreement often talks about the U.S. Attorney's Office. It often talks about this specific office. It often talks about the United States Attorney. Yes, it happens to use the United States in this one spot, but everyone understood that this deal was really about that U.S. Attorney's Office. And the Second Circuit Court of Appeals agreed with the prosecution, and the Seventh Circuit, where I'm in, the Chicago's in, the Seventh Circuit Court of Appeals also agreed with us. The problem that they have is that the Fourth and the Eighth and the Third Circuits disagreed, and arguably the Ninth. I mean, there's a disagreement about that between the two parties. But the bottom line is, some courts of appeals are like, no, one U.S. Attorney's Office can bind the entire United States Department of Justice.
Yeah.
It's a difficult problem, and it's a better argument than most criminal defendants ever have, and it's all because of this crooked deal. I think it's
really, that's what that's where this comes to, you can see this in the government's opposition brief, they're just basically saying, like, this is just highly unusual and sort of unethical, I guess. They're not fully saying that straightforwardly, but they're sort of implying it in terms of the way that it's worded. But it is, a potential way for Ghislaine Maxwell to get out of this completely. One of the things that I was thinking before I read her cert petition, I mean, if you were to agree with her, I originally thought if you agree with Ghislaine Maxwell that this non-prosecution agreement prevented the Southern District from prosecuting her, then you are implicitly conceding that the Southern District did not have the ability to prosecute Epstein either. That
True.
somehow he should be a free man. Though I guess she's trying, the brief actually does a very clever job of trying to split the hair there, because I think they're anticipating that concern. And she's basically suggesting, no, the Southern District could go after Epstein because only, the Southern District of New York could go after Epstein because the non-prosecution agreement only specifies the Southern District of Florida with respect to him, but they weren't allowed to go after me. And that I think creates a really weird outcome, right? Where the person who's actually the party to the agreement is agreeing to less protection than, a bunch of randos that prosecutors don't even know about.
Yeah, I mean, this is why, people wonder, why do lawyers spend hours and hours and hours negotiating contracts and sitting there with red lines? This is why, because just sloppy wording can create a lot of problems later on. I'm going to have a bit of a hot take. Can I have a hot take, Asha?
I have a hot take, and I think I have a hot take too.
Okay, here's my hot take for you.
Okay.
If this is taken by the Supreme Court, the hero for those who want to see Ghislaine Maxwell in prison is going to be one Samuel Alito, who really dislikes criminal defendants and almost always rules against criminal defendants in every case in front of the United States Supreme Court. And I think will not like Ghislaine Maxwell and who she is and what she stands for. And I really wonder in this instance whether, I don't think he's going to bring himself to vote for a criminal defendant for one of the first times in his long career on the United States Supreme Court. So I think one of the challenges that Ms. Maxwell and her counsel have in this case is that they're representing a criminal defendant in a case in which, don't think that the Democratic appointees are going to be enthusiastic about Ghislaine Maxwell. I don't know if they're going to get all the swing votes, and they definitely cannot count on Samuel Alito.
Okay, that's an interesting hot take. I will say, though, that Samuel Alito, who's like, basically MAGA brain, and clearly loves Trump, right now, the Justice Department has officially opposed, has basically said that the Supreme Court should not take this case despite the circuit split, that, this is not worth their time. I will be very interested to see whether the Justice Department changes that position. I don't know. I mean, that would be highly unusual, I think, but you can imagine that they might do that as sort of a hint, can you take the heat off of Trump and just let her go or something like that. But my hot take is this. If Ghislaine Maxwell has suddenly pointed the fingers towards, all of these other co-conspirators who were all in on this, then why wouldn't this non-prosecution agreement apply to them too?
Oh, that's an interesting take. What if they were just customers and not co-conspirators? What if they were just not customers, but beneficiaries, or however you want to look at it? They were one-off abusers.
Well, then it's in their interest to basically say, no, I was actually way more involved than that, and this, this agreement applies to me. Yeah,
what happens, though, in that hypothetical universe, this is going to happen.
The co-conspirators, you're agreeing to commit a crime. And so, all of them, if they're going to this island and on board with Jeffrey Epstein, they are co-conspirators to some degree.
Yeah, it's an interesting take. What may happen, though, in this hypothetical universe is Maxwell gets her plea deal, or she gets or not plea deal, but her, cooperation deal, or she gets immunity or whatever, pardon, or whatever she, gets out of this. And then just, mentions that so-and-so, I used to see Bill Clinton there, or whoever she's going to allege. And then, they'll investigate, and they'll spend years investigating. It won't really matter whether they can prosecute the person or not, right? It'll just be the
I think that's a key point here, is that one of the things that Trump loves and his base loves is just investigations. Even when he had the perfect phone call with Zelensky, it was about going on CNN and announcing an investigation. I don't think he really cared whether there was actual investigation into the Bidens. He just wanted people to know that they were being investigated because that gives him fodder, the same way that it gave fodder for Hillary Clinton. So I think that's, it's true that they could just use that to kind of throw to the base what they have been promising. I will say that I think there's a potential reverse Uno that, depending on who is accused and how guilty they actually are, and or what they know about the paper trail, what if they turn around and sue Ghislaine Maxwell for defamation?
Yeah, maybe.
I'm just saying, that's another way, by the way, for this to sort of backfire, because depending on who she points the finger at, if they were to sue for defamation, then that could lead to the discovery that then gives an avenue for some of this information to actually come out.
Yeah, it's interesting. I mean, it depends on who the person is. A public figure, it's hard to get there, right? To make your case. Trump loves suing people for defamation because he's the president, and then they pay him off just because he's the president. But for the rest of us, it's challenging to bring those defamation claims.
If I were a former president, even
that
this, like Obama
person?
with Russia, maybe not with Clinton, but I'm just saying, because Macron, I don't know if you know this, but President Macron and his wife have sued Candace Owens for defamation.
I have seen that.
So
she's doubled down. She's like, she's like, double down. She's like, how you double your chips sometimes. When you're doubling down in blackjack. She's all in on that false statement. I'm
just wondering that there is. I think it does raise this idea that there is a way to fight back, and sometimes maybe taking a page from Trump's own playbook is a way to respond. The other thing that I would say is that, New York is able to prosecute Ghislaine Maxwell. I published a cafe note today about this.
Mm-hmm. Yeah.
And they have, since 2020, closed the so-called pardon loophole, which, is an exception to New York's rule that, in general, people who are already convicted under federal charges, the state will not prosecute them. But unless if you're pardoned by the president, then the state does have permission. So I think that's another avenue to kind of get her on the hook.
Yeah, she's got that's why she's being very careful about what she says. I mean, there is talk about her testifying before Congress, and her attorney correctly, well-known defense attorney, asked for immunity, and that's the right move there because she's still got potential liability for her statement. So I think that she is not out of the woods. She's got a lot of problems, but she definitely has. That's why this is complicated, but she's got definitely some pathways to either reduce sentence or getting out of jail free, which is a true travesty given how heinous the crimes are that she committed.
Totally. It's hard to believe that we have sunk this far, but here we are, and we will probably get lower.
Yeah, unfortunately. So, Asha, Epstein, of course, is part of another big story this week. Trump was named, we talked about this last week, in a blockbuster story by the Wall Street Journal about his well-wishings for Jeffrey Epstein. You and I and the rest of the world don't get invited to write notes and participate in his birthday celebrations, but his close friends like Donald Trump do and did, according to the Wall Street Journal. Trump sues the Wall Street Journal and sues, by the way, Rupert Murdoch personally. Rupert Murdoch owns the Wall Street Journal and Fox News. And in what is something that I would say an audacious move, files a motion to compel an expedited deposition of Rupert Murdoch, who is in his 90s.
He's 94.
94 to sit for a deposition. And why? Well, his advanced age means that if this lawsuit pursues its ordinary course, he may not be available for a deposition in the many years that would come before this complaint is, thrown in the trash bin.
And the idea is that they are saying that his editorial control over the entities that he oversees, that he's very directly involved in what gets published, which I thought in itself was a very interesting, point that is now, very acknowledged, I guess, but that he takes a very active role in what stories get published, what stories don't, how they're framed, etc. And what their argument is that he's relevant because I guess when the Wall Street Journal was going to publish the story and they reached out to Trump for comment, and of course Trump got very upset and said, this is a fake letter, this story is false. But he called Rupert Murdoch, and Murdoch was like, I'm going to take care of it. But then of course Wall Street Journal ran the story, and so for a public figure they have to show that in order to prove defamation, they have to show actual malice. And so they are saying that the fact that they alerted Rupert Murdoch to the fact that this was false and that he allowed this to go forward anyway because he had the power to stop it if he wanted to, is what demonstrates actual malice. So they're saying that he goes to an element that they have to establish.
Right. And just so we make sure that everyone's on the same page here, who's watching or listening, what actual malice means in this context, when you're a public figure, is not that you had any mean intent or you were mean, but it's actually that you knew something was false that you published, actually knew, like I know this is a false statement, but I'm publishing it anyway, or you had reckless disregard for the truth. Now, another thing, that element of this Rupert Murdoch deposition that's interesting, of course, and, just to bring, it's almost like season 3, like, when you watch these shows, like, oh, there's this actor from season 3 and you're like, I kind of remember this guy. Like, well, the Dominion lawsuit comes back from 3 seasons ago, maybe, where, that was a big deal. And in many ways, Rupert Murdoch's testimony helped seal the deal against Fox News, because Rupert Murdoch, in the deposition that he gave in that case, was very upfront about the fact, like you said, not only that he was very involved, but he thought that the whole election 2020, conspiracy that Trump was trying to push was bullshit. I mean, he was very upfront that I thought it was complete bullshit and it was hogwash and there was nothing to it whatsoever. And he knew this. And really the theory that Dominion had was that this guy knew it was false and didn't give a crap. And that is something that, ironically, Trump's lawyers are there's an element here to which it's like, well, this guy already had to pay out $787 million because he was peddling falsehoods in this other case. Oh, by the way, because he was doing Trump's bidding. Now he's not doing Trump's bidding. And so we need to depose him right away. Now, that's very fascinating turn of events. Yeah,
there does seem to be a vindictiveness here of, now we're going to drag you in and make you sit for this deposition because you didn't give us the favorable coverage that we are entitled.
You didn't do what you did before that led to you getting sued for $700 and settling for $787 million. I would also just say, just to level set for people, because a lot of people listening to this or watching it on YouTube or the Midas Touch Network may not realize is that how unusual this is. So companies get sued all the time. And so a lot of times, like, executives get named as part of that. That happens. But those lawsuits take many years to proceed. That happened in the Dominion case. It wasn't like it happened immediately. It wasn't like it got resolved in 2020, 2021. It took years. And there's motions to dismiss that could get rid of all or part of the case. There's all sorts of things that happen before you even get to depositions, which may take many months, potentially years from now. And maybe depositions might never occur if a motion to dismiss is granted. And so having a CEO or chairman or owner of a big company like this deposed at any point is a big deal. Like, you kind of have to show, like, hey, there's some reason why we need to depose this big head honcho, particularly a guy who's, in this case, advanced age, and there's lots of other people running the business.
That's major health problems.
Yeah. And so to depose him before you even file your motion to dismiss is really something.
Well, we'll see where this goes. I mean, Trump is not happy about that article. I would say that the Wall Street Journal article is really what gave a lot of fuel to the fire here. Because, of course, people were upset about, DOJ saying they weren't going to release this or whatever. But I think that was a turning point when that letter was, when the Wall Street Journal published their story about that letter.
Yeah, it's interesting, and more may be coming. One thing, the reason I say, Asha, that more might be coming is because Trump himself is adding fuel to the fire. I mean, message discipline is not one of Trump's strong suits. And recently, this week, he riffed to a group of importers on video and audio. Okay. I mean, you can watch it online on C-SPAN aired it. Trump basically said that Epstein stole at least one of his people. And stealing his people, almost the way he talked about it is almost like chattel slavery.
Yeah.
Like, he was a plantation owner and somebody came and stole one of the slaves off the plantation. And the person, and then a reporter said, if it was somebody working in my spa and he stole this person, he stole this person away, essentially. And then one of the reporters like, are you talking about Virginia Giuffre, who was a person who actually came forward and was seen as an inspirational figure to a lot of victims?
Yeah. Because
she, by coming forward and putting herself in the line of fire and accusing, I think, not only Epstein, but also like Dershowitz and others, really took a lot of heat and put herself out there and gave others courage to come forward. And Trump said it may have been her. And in fact, I believe there is some evidence, right, that she worked in Mar-a-Lago.
Yeah, I think she said that she worked there because she was checking the dates, and she worked there till 1999 or 2000. By the way, while she was underage. And why does Trump know about the employee working at his spa? I mean, I assume Mar-a-Lago has hundreds of employees. I mean, it's all weird. It's all very weird.
What's also
to remember from 25 years ago that this specific person was working at his spa.
Well, he also said he cut off Epstein because Epstein stole his person. Not because Epstein was like some sort of creepster who was, targeting young underage women, minors, but rather because he stole his person. And so I cut him off after that, after he stole my person.
Except he was still friends with him for like 4 years after that. Yeah. And by the way, I believe that she was, quote unquote, stolen because Ghislaine Maxwell recruited her from Mar-a-Lago.
Well, that's why Trump is wishing her well.
So anyway, a lot is coming out in his blabbing. I think he, one of his tricks is sometimes, I think, to say things out loud. And then, because one of the piece that gets people, his base worked up is the secrecy. So sometimes when he just says it, then they're able to say, well, obviously that's not criminal because he admitted it, or, whatever. I'm not saying that particular incident is criminal, but my point is he will do and say things in the open that sort of neutralizes it. And maybe that's going to be his plan moving forward. But honestly, if that's what it is that's in the files, and just release the files, man.
Yeah. Well, I think there's more to come, Asha. I don't think this is the last we're going to be talking about Epstein or Maxwell, or potentially this lawsuit against the Wall Street Journal. So, Asha, before we go, I think we have a very special subject to discuss.
We do. So many people who have been listening to us for a little while might remember that maybe about a year ago, we were talking about a cruise that we were going to host this summer. I forget where it was going to go. It was going to go to some fun places, but for reasons beyond our control, we ended up having to postpone. It was just not going to work out. It was going to take place this summer. However, we are back and we have a new cruise that we are planning to host for next summer.
Yes. And so what does this mean? What are we talking about? We're talking about a cruise because we have a lot of new listeners now and a lot of new viewers. What this would literally be is a cruise, in this case to Alaska, in which you would have an opportunity to not only be on like a nice, fancy, fun cruise where you guys can enjoy yourselves, but also we would have a real community aspect to it. You get to, we would be on the cruise. We would be interacting with you. We would have some events on the cruise. And by the way, we'd also get the group together in advance and have some conversations and leading up to the cruise.
Yes. In fact, on August 13th at 6 p.m., we are doing a virtual cocktail party where there'll be representatives from the cruise line, the people who book the stuff there to answer questions, because we got a lot of questions last year we weren't exactly sure how to answer. So this time we have the people who actually do it there. You can sign up. We'll have the information in the show notes, and it's all virtual. It'll be on Zoom. We'll be there. And there are some early booking specials, but I'm really excited. I have always wanted to see Alaska. I think it will be really great to be with like-minded people, to be appreciating the beauty of our country, to hang with you, Renato, and, maybe talk about how we're going to right this ship, as it were. And you can say a little bit about the actual cruise line, because you've actually used them before.
That's right. So my wife and I went on this is Oceania Cruises, ocean with an IA at the end. And it's really nice. Like, it's not like one of these massive cruise lines where you feel like you're part of a floating city and there's just like an unlimited number of people. And for, sometimes people they get anxiety with massive crowds, or they don't want to be lost in the crowd, or they don't want to be in, kind of a cattle call for a meal. This is not like that at all. It's like a very small boat. It's an upscale experience. And it's a real opportunity to have something that's nice, but it's not, it can hopefully fit within many of your budgets as well.
Yes. And it will be departing from Seattle, returning to Seattle from July 14th to July 21st, 2026. So hoping that you will tune in for our virtual cocktail party.
Absolutely. Link will be in the description.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.